Hi, I'm John Leonard. I'm a corporate lawyer at Fairfield and Woods, Denver, Colorado. I'm talking to a number of my colleagues about what they do here at Fairfield and Woods in a series of videos that are on our website. They're short snippets about the law and how they interact with your life, your business. And we just did one with Tim Jordan on wills and trusts. Today, we're talking with Mark Smith on intellectual property, trademarks, trade secrets, copyrights, and patents. We just did one on trademark, but I want to talk about, when people want to get a trademark. You've talked in your first tape about what a trademark is. Let's talk about the process of you counseling somebody and then going to register them at the federal level and why anybody would want to do that. So let's talk about, if I'm a client and I come in and why do you want me to give you more than one mark if I think I have a mark? And then once we pick a mark, what do you do? How do you protect it?
Okay. The client walks in the door. They have too often already selected or already used a particular mark, and they're invested in it both financially because they've done a rollout of that particular mark, or emotionally because they say that's the mark for me. And we have to counsel them that that mark may not be available because other people may have already registered that mark. And if there's a registration or an application that's pending that then matures into a registration, that person or entity is going to be the superior right, and they will be able to sue you for infringement. And you're going to have to back out and change your mark and adopt a new mark.
And so where do you look? There's a federal register, but then there's common law use. If I come in with a mark, what's the common law and federal search that you do? And that's why we need to counsel people.
Yeah. The searches some searches can be done just on the trademark office's website. That's a fair start, but it doesn't give you a complete picture of the registrations that are out there. It doesn't include state registrations. It doesn't include foreign registrations. So we recommend that we use a database search that this allows us to search all of the registrations that are relevant to this particular use and goods and services. So that's one part of the search. We also do a search on the internet, and that's a means by which we try to find out, is there a common law user out there that we need to be aware of? And if there is, that common law use is going to be something you're going to have to reckon with. And it may be very localized and in a very small geographic area, or it may be nationwide, depending on the circumstances.
What's the process of federal registration of a mark? Why would you do it? How long does it take?
The registration takes about a year because the examiner is not given the application for a couple of months after you file it. And then they do a research of their own of what is registered, what is this mark functioning as a trademark, and some other unique aspects of trademark law, whether it satisfies those requirements. But then the process is the examiner will send what's called an office action, either allowing the trademark if they found no conflicting trademark registrations or applications that precede it. And then if they pass that muster and it goes to allowance, then you will get the registration at sometime in about a year. And at that point, you are then permitted to use the circle R with your mark. Prior to that, you must use TM or SM, depending upon the circumstances.
Why bother with registration? What additional protection would it give? Because you've already mentioned common law marks. Most people out there, most businesses, they don't register all of their marks or any of their marks sometimes. Why go through what benefit do you get from federal registration?
Federal registration is very powerful because it gives you priority and trademark rights to exclude others from similar goods and services throughout the United States and its territories. And one filing, you get coverage throughout. Whereas in common law trademark rights, you only gain rights over that trademark to exclude others in those geographic areas in which you operate and actually market. So your breadth of coverage is far greater with a registration. And it also gives you the presumption of ownership and the presumption of use. You don't have to prove that if you were to go into an infringement case.
And I guess it also, for those that get proper counseling, if you've registered them, it's easier to find something and you can advise people on how to avoid a problem. So,
Right. That's why you do that pre-filing search and pre-selection search. So you can avoid that.
well, great. We're talking today with one of my colleagues, Mark Smith, about different aspects of intellectual property. We have a video on what intellectual property is, and we just did 2 on trademarks. We're going to turn to copyrights next, but you can sure call or email Mark whenever you have questions and hopefully come in and talk to him. I find him extremely informative. So thanks for joining us today.